All right, very good. Good morning, Council. This is the March 7th docket of the Kansas Court of Appeals. My name is Steve Hill. I have been designated by the Chief Judge as the presiding judge of this panel, which basically means I get to keep track of time and let you know how you're doing. It's my honor and great pleasure to be on this panel with Judge Powell and Judge Klein. We're all three judges of the Court of Appeals. We've read your briefs. We're ready to go. We may have a few questions, so be prepared for that. I can tell you that 15 minutes per side is not very long. So I suggest you give us your best shot as soon as you can when you're making your argument. I'll ask you to enter your appearances here in just a second, but if you're representing the appellant, I would like to know if you wish to reserve any time for rebuttal. So with that, the first case is 123-436 Michael P. Estivo, DO, versus the Kansas State Board of Healing Arts. In this particular case, the Board of Healing Arts is the appellant. Counsel, your appearance, please.
May it please the court, Courtney Sisman, General Counsel of the Kansas State Board of Healing Arts, appears on behalf of the appellant, and I would like to reserve 2 minutes for rebuttal.
2 minutes?
Yes, Your Honor.
You got it.
May it please the court, Kelly Stevens of Forbes Law Group appears on behalf of Dr. Michael Estivo, the appellee.
All right, thank you, counsel. Ms. Sisman, it's up to you. What do you want to tell us?
So the Kansas State Board of Healing Arts is an executive agency that's tasked with licensing and regulating 16 different healthcare professions in Kansas, including the practice of medicine.
We understand that, counsel. I don't think we need to get into the fundamentals right now. I basically want to know from you is what is it that the board wants from this appeal? What relief are you asking for?
The Board of Healing Arts is requesting that this court reverse the district court's order and affirm the board's final order in its entirety because the district court erred in reviewing several issues and had other instances of judicial error. So turning to the first issue in this case, the district court erred when it sua sponte asserted a legal requirement that an administrative agency must plead allegations with statutory particularity and reverse the board's conclusion that appellee violated KSA 652837B24.
Now, let me stop you right there because I want to make sure I understand the record on this. This came out of the blue. Did either of the parties say that they didn't get notice of this?
No, Your Honor.
Actually, subsection 24. I'm going to refer to it instead of all those numbers. I'm going to refer to it as subsection 24 of the statute. Did anybody argue, hey, we didn't get notice of this? This is unfair. Did anything like that happen?
No, Your Honor, and that's critical in this case. In this case, the district court sua sponte brought it up. And that's important because, you know, issues that aren't raised at the administrative hearing are generally deemed waived, but the court did go ahead and raise this and bring it up erroneously. The notice requirements are set out in the Kansas Administrative Procedure Act. You know, there has to be a notice and an opportunity for a hearing, and the notice should be reasonably calculated under all the circumstances to apprise the interested parties of the pendency of the action and afford any opportunity to present objection.
Did Dr. Estivo know what the board was saying about him and what it was charging him with?
Absolutely, Dr. Estivo did know. It is clear from the petition and the agency record that it was the standard of care that was being challenged with respect to his treatment and specifically post-operative treatment of patient one. That was never at issue in this case. The facts alleged in the petition are exactly what the board relied on with the substantial evidence in making its finding of subsection B24. It's not as if this came out of nowhere and the petition had, stated all the facts of the standard of care and then had some, improper billing issue. That was not part of the facts of the petition.
Did you ask the court to correct this error?
We did. We filed a motion to amend to allow for an interlocutory appeal, and the district court denied that request. So in our opinion, this was clear judicial error as it proposed a completely novel legal requirement and quite frankly should not have been brought up because Dr. Estivo knew exactly what it is he was being charged with. He had proper notice and it should not have been reviewed. Additionally, the agency record in this case supports that there was substantial evidence for B24, which is critical because if this court reverses the district court's order, B24 is back in play and the substantial evidence is clear. So October 9th, Dr. Estivo performs a surgery and that following day, the patient begins experiencing left leg numbness and she's unable to move it. She has no strength. She then gets a PT evaluation, which the physical therapist documents that she's unable to move it. And then Dr. Estivo sees this patient before discharge. He also notes that there's lower left leg extremity weakness and she's not moving it. It's at that point he should have ordered an MRI or any sort of diagnostic imaging, but he failed to do so. And then she has 2 subsequent follow-up visits with him where she's again experiencing lower left leg weakness and numbness and tingling. And he again fails to order any diagnostic imaging. So the board's conclusion of B24 was supported by the medical records in this case, the board's expertise, and was supported and bolstered by Dr. Burton's testimony in this matter. Dr. Burton testified that post-operatively is when time is of the essence. And that in this case, he said specifically, any reasonable competent spine surgeon, when faced with post-operative patient with new neurological deficit, is going to get an imaging study, but particularly after a spine surgery where the spinal implants have been placed in proximity to the spinal canal. So there certainly is substantial evidence in this case to support B24, and it was not unreasonable, arbitrary, or capricious. Turning to the cost issue in this case, it is the board's position that the district court again erred in reviewing the cost issue because it was never properly preserved in the administrative hearing or even in the brief for petition for judicial review.
Well, counsel, as I understand it, both sides say the other side pay the costs. The board said the doctor should pay the costs, and then the doctor said the board should pay their own costs.
Sure.
Is that sufficient to preserve the question for the court to decide?
That's not sufficient in our opinion. So the board the litigation counsel filed a petition or a statement of costs, and appellee had 44 days to file any sort of opposition to that. And the record's clear that appellee was represented by competent counsel and absolutely knows how to object and file reply briefs, but didn't. But regardless, even if this court finds that the cost issue was properly preserved, the district court erred in its legal standard regarding the assessment of costs. As
I understand it, the district court said, listen, you have to apportion these costs. It's required, not optional. Do you disagree with that interpretation?
We absolutely do, Your Honor. In terms of KSA 652847, that is the statute which governs assessment of costs. And that statute is clear and ambiguous. And it's, the board can assess costs when they're adverse to the licensee in such proportion as the board may determine upon consideration of relevant circumstances and the involvement of the parties. The district court incorrectly supplanted the statutory requirement that the board determined the degree to which the board's order was adverse to the licensee. Nowhere in the statute is there that requirement, and nor is this statute ambiguous. So we
In
do.
practice, though, there has been apportionment of costs in the past in other cases, isn't that right?
With respect to board cases or other cases?
With board cases.
In terms of other board cases, I can't recall off the top of my head, but there certainly are cases in, well, Shine versus Kansas State Board of Healing Arts. There is an unpublished decision in which the board did properly address the assessment of costs in apportionment and was not otherwise unreasonable, arbitrary, or capricious in it.
Thank you.
Yeah.
Now, counsel, you know where I'm going in the next question is all of this is very interesting, but is the board dead in the water, so to speak, because you have acquiesced?
The board is not, Your Honor. In terms of acquiescence is disfavored under the law, and what is favored is the right to appeal. And we believe that the doctrine of acquiescence does not apply, but even if it does apply, that the board in no way acquiesced to the district court's order.
Tell me why it doesn't apply.
Okay. The doctrine of acquiescence, as you guys know, is when a party simply their right to appeal is cut off because they've somehow accepted the benefit or judgment of the order. But there's an exception to that general rule, and that's when, so long as the issues on appeal don't affect the obligation of for the payment or the right to receive such portion of the judgment. So this main exception does apply because although the board did accept refundable payments, Appley submitted for, this was pursuant to mandated order on remand. The payments are not the sole issue in this case. But even if the doctrine does apply, the board did not acquiesce. In this case, the board was placed in a really tough position. We were appealing the district court order. We tried to get an interlocutory appeal. That was denied. But at the same time, we're simultaneously being asked to do this order on remand with an order we disagree with, or potentially face contempt as a consequence. So our interlocutory appeal was denied. We noted our continual objection all throughout as we were proceeding with the order on remand, so we were not also held in contempt. Now, Appley has cited Troyer v. Gillian to support the position that the board has acquiesced, but this case is not controlling in this matter and is very distinguishable. In that case, Troyer was not faced with an order from the district court in which it was also required to do a remand and face potential contempt as a consequence if it didn't. He simply had a judgment for joint venture assets and then sought to enforce that. The board's position in this case was absolutely consistent throughout. We immediately tried for an interlocutory appeal. That was denied, filed our notice of appeal, and throughout the order on remand continually noted that we are not waiving our right to appeal. We are preserving anything related to in our opinion, the legal errors in the district court's order. But even if this court finds that the board has acquiesced in some manner as respect to costs, that does not make this whole entire case moot. The case is only moot when it's been clearly and convincingly shown that any case or controversy has actually ended. Again, as in our opinion, the doctrine of acquiescence does not apply. But even if it does,
do the cases allow partial acquiescence? In other words, since you have approved the doctor's payment plan, does that take the issue of costs off the table?
In our opinion, the issue of cost is still there. But even if this court finds that the issue of cost of acquiescence is completely gone, there are still cases to support the separation of that in terms of mootness. Hewitt versus Vaughn, which has been cited, is one of them. There, the court actually did find that they were so intertwined that the issues was completely gone. But the dissent in that opinion noted that, hey, no, actually, these were under two solely separate statutes, and they actually weren't intertwined and should have been separate. And in this case, it is clear that these issues are completely separate. So cost issue aside, there's still this issue of whether or not the district court erred in sua sponte asserting a statutory particularity requirement in terms of pleading.
Counsel, I've interrupted you a few times here. You've got about a minute and a half left before you get into your rebuttal time.
Okay. I would just conclude with at this point, Your Honor, that the board does request that that this court reverse the district court's order and affirm the board's final order in its entirety. It's important to remember that at the district court, the appellant who challenged the board's final order bore the burden because the board's final order had a presumption of validity, and they continue to bear that burden even throughout this appeal.
Any questions, judges? All right, thank you, counsel.
Thank you, Your Honors. The decisive fact in this appeal is that the board cashed the checks from Dr. Estivo for the determined amount. They may not have intended to, but they committed a very voluntary appeal killing action by doing so.
Counsel, let me ask you
Yes.
a question or two so I make sure I understand the record. As a result of all of these hearings, the board directed the doctor to attend a class on documentation, and after remand by the district court, ordered him to, they lowered their costs and said, this is what you have to pay up or work out a payment plan. Your doctor submitted a payment plan and they approved that. Is that basically what happened?
Yes.
Now you're telling us that this cost issue is so intertwined with what the court did with subsection 24, for example, and all of that, that this just takes the whole case and moots the whole case. Is that correct? There's no
Yes.
more justiciable controversy. Explain that for me, will you?
Yes, Your Honor. So the subsection 24 violation is key to the board assessing the amount of costs they want. Without that, you have exactly what the district court ordered, which is, hey, all you have is a record keeping violation. He already completed the CME. You throw that B24 violation out of here, you've got to go back and redetermine the costs in proportion, considering all the relevant circumstances, and the board provided direction. So every issue in this case is related to costs, because validating that B24 violation has no effect because the board didn't order any discipline tied to it. They already had the record keeping violation and they sent him to a CME he had already completed. So without that B24 violation, the board loses on its argument that their assessment of cost was correct. Whether the court should have entertained the notice issue about the B24 violation. Again, it's all tied to, was their cost appropriate?
Now,
And-
listen, as I understand it, the doctor did not raise lack of notice in any of the
Correct.
pleadings or in any of the argument, correct?
Yes, that was raised sua sponte by the district court.
In other words, you knew what the arguments were, the charges were that they were making against the doctor. And
No,
you could prepare a defense.
the board, Dr. Estivo was not aware of the repeated negligence violation, the B24 violation, until the final order came out. He was trying a gross negligence case regarding his postoperative care. And at no time was he able to present arguments, legal authority, or anything else as to why an act of negligence should be all encompassing the decision-making on those repeated visits, was part of one act of negligence.
But
or
the board
whether-
was, the board was consistent, was it not, that said, we think this is gross negligence. But just in case it isn't gross negligence, we think it's negligence.
Yes,
And 24, subsection 24, I call it, because I don't remember all of those numbers, quite frankly, says, repeated acts of negligence, and that's, you could make a defense whether you did or not. It's the doctor's choice. But you knew that was the nature of the allegations, didn't you?
Dr. Estivo knew that negligence was at issue. But at any event, those issues are all rendered moot because on remand from the district court, and the court's order only told the board, go back and redetermine these costs, considering all relevant circumstances and in proportion to those circumstances. That was the court's directive.
Yeah, do you read that court order to say you have to apportion them? Or or do you view that order as saying, board, take a look at these costs again?
The board said, gave direction, look at these factors, and then determine the appropriate proportion. The court still gave the board latitude to fashion their costs amount. And that was all the board required them to do. The board never said, oh, and then you must issue an order enforcing this. You must accept payment. And I mean, the idea that the board was risking contempt is ridiculous. They did what the court ordered, and then they voluntarily went further. They said it was under protest. But the case law, Varner, Labette College, all state that merely reciting your intent not to waive appeal is not enough. And the board accepted payment, and there's absolutely nothing in the record that indicates these payments are somehow refundable. Dr. Estivo received a receipt and paid them in full. And so that cut off the board's right to appeal the costs issue and all of the very intertwined issues that all relate to, could the board do that with that B24 violation that they need for no other purpose than to support the amount of costs they need, that they want. The court is saying, or the board is saying the amount that they awarded was insufficient. And at the same time, they're accepting that amount. These actions, again, were entirely voluntary. The court didn't order them to enforce and accept. The board absolutely could have stayed the enforcement of that. They know how to do that. They did that for Dr. Estivo when he filed his initial petition for review. They stayed that pending appeal. They absolutely could have stayed this matter after they made that redetermination of costs. And the issues in this case, as I've stated, are not separate and distinct. They all relate to the board's desire for an increased cost assessment. The board didn't act out of self-protection. This case is distinguishable from Ullman and Brown. In Ullman, no funds were actually collected. Here, the board collected funds. In Brown, the amounts that were paid were not in dispute. Therefore, the assessment of those amounts couldn't be affected by any decision on appeal. So those cases are very different. Here, the whole issue is the amount of costs.
Does Hewitt Vaughn help you or hurt you or is neutral?
I think Hewitt Vaughn is helpful in that both the fine and the censure were tied to her conduct. And even though the costs are in a different statute and the fine is in a different statute under the Healing Arts Act, they both relate to the conduct in such that that's how you determine the relevant circumstances in the portion that should be assessed to each party. Additionally, case law supports that stating that you have no intent to waive your right to appeal is insufficient. And again, both Varner and Gulf Insurance support that. And because of all of this, the remaining issues in this case are rendered moot. There's nothing left that the board can fashion an effective relief for the board. The costs have been paid. Reinstating the B-24 violation does nothing. It doesn't up the discipline because there was no discipline for that. It doesn't affect anything. Finding there was substantial evidence for that B-24 violation does nothing. And the costs, the fact that the board states that Dr. Estivo didn't preserve the issue on appeal, he absolutely did. He stated the board should bear its own costs in his initial brief. And
basically, that's what both parties said. The board said the doctor should pay the costs, and the doctor said, no, the board should pay the costs.
Right. And if
is that enough to preserve the issue?
Well, if you look at it, I think it is. But in addition, the notices that the board issued, their very first notice of intent to review the initial order did include a statement that cost would be an issue, but then the matter got continued and all the subsequent notices did not include the issue of costs. So the board absolutely could have handled this differently. They could have bifurcated the matter and provided, made their determination, and then had the parties come back and argue costs. And that would have given Dr. Estivo a more meaningful opportunity to do that. And so it was appropriate for the district court to find that the issue of costs was preserved. And also the court was correct in determining that the board misapplied the statute. The board entirely ignored the term in proportion and all relevant circumstances. The board simply found that they had succeeded on their record keeping and a much lesser charge. If you take that as fact, then said all of it should be borne by Dr. Estivo. They didn't consider all the relevant circumstances, and the court, when throwing out the B-24 violation, said, hey, go back and look at this again. You need to make a proportionate determination. It didn't say what those amounts were. And you can distinguish that from the unpublished Shine case that the board cites, where the court made an actual determination. The court did not disturb the board's discretion to evaluate those circumstances. But again, all of these issues are entirely moot. They're all interrelated to costs, and the board has clearly killed that issue by its acquiescence in accepting the payment. Certainly, the board would argue that Dr. Estivo had acquiesced by accepting or by making that payment, and there's no reason the board shouldn't be held to that same standard. They absolutely expressed over and over again that was not their intent, that they were doing all of this out of, under the mandate of the court, but there was no mandate from the court that they enforce and accept payment.
Counsel, does it matter that Dr. Estivo didn't cross appeal the assessment of those costs. And so it looks like the board is really just trying to see if they can get more costs. I mean, it's a given that he's going to pay the amount since he didn't cross appeal, correct?
Correct. He didn't initially on remand. When this finally did get to the board for a full hearing on the costs issue, Dr. Estivo argued that he should only be assessed, I believe it was about $1,100. And then he did not disturb the final decision and cross appeal. He accepted the $5,000, but so did the board. And Dr. Estivo's acceptance of that amount certainly doesn't change the fact that the board acquiesced. This is still in controversy. They're complaining $5,000 was not enough, and yet they accepted it. And that's what's critical to this.
So is it your position that even though it was only a partial payment regarding, I mean, when you consider the full amount that the board is looking for, that they're still stopped from seeking additional payment of costs because they accepted that smaller amount?
Yes, it's no different than if they accepted a partial judgment on a plaintiff's verdict, and they are saying, well, that was wrong. That's the wrong amount, and taking it and then trying to get more, which is exactly what the board is doing here, because the only reason we're here is costs.
Thank you, counsel. Any other questions, judges? All right, very good. Let's see, you wanted 2 minutes, counsel? You've got it.
The whole reason we're not here is just simply because of costs. Again, it's in part because of the district court sua sponte raising the issue of the notice requirement. Again, just driving home, Hewitt Vaughn is distinguishable and actually hurts Epley's position in this case because Hewitt Vaughn was so intertwined because it was a punitive fine in that case under statute. In terms of B24, in this case, is not at all intertwined in terms of the assessment of costs, which is under a separate statute, not a punitive fine under KSA 652836A.
Counsel, it strikes me that the board might want to make sure that future cases, district judges don't do what this judge did. Is that one of the reasons why you're appealing?
Absolutely, Your Honor. In terms of the sua sponte, raising that issue sua sponte, yes.
Or at least ask the parties to brief the issue.
Correct.
Anything further?
Nothing further, Your Honor.
All right, thank you. Listen, it's been a very interesting argument. Thank you both very much. We'll take this case under advisement and we'll issue a written decision when we can. So thank you very much for your efforts here today. And with that, we will adjourn.